Just before we get started, Your Honors, I wanted to introduce myself. I'm Robbie Sickler with Gilday Law. Somehow I think the clerk has Mr. Rosenberg down as taking lead on the Segars portion. So we had a little trouble logging in this morning, but I did want to let you know that we're going to be taking lead for the majority of the argument here, despite the fact that I think it shows Rosenberg as being the lead for that.
That's right, Mr. Rosenberg. You guys have worked out your sharing?
We have, Your Honor.
All right. Mr. Sickler, you're going to take the bulk of the time, and if anything, you'll let us know or give Mr. Rosenberg the high sign when it's time for him to talk, if there's any time left.
Your Honor, I'll be saying unless Your Honors have a question.
Okay, you're going to say me too? Okay, very good. All right, it's 9 o'clock now. Welcome to a session of oral argument before the 5th District Court of Appeal. I'm Judge Jim Edwards. Joining me are Judge Eric Eisnagel, and we welcome Judge Jordan Pratt to our court and to his first oral argument. Now that he's got almost 2 weeks under his belt, I guess, maybe a little bit more than that. We will have 2 cases that are traveling together this morning. Case 22-1410 and 22-1557, Cynthia Taylor versus Nicholson-Williams et al. And Cynthia Taylor versus Edward Segars et al. And we've got the timing worked out for the appellees. You'll see in one of the little boxes there is a clock. It counts down. 20 is the total time each side has. The lights come on. They're a little difficult to see with Zoom. When the yellow light comes on for the appellant, that means you're into your rebuttal time. And I'll try to remind you or point that out since it's not perhaps as obvious as normal. Typically, we allow 5 minutes for rebuttal. If you want any other time, just let us know and we can change the time setting on that, Mr. Taylor. If you have some kind of noisemakers, which we all do, make sure they're on silent or muted or turned off. I'd caution you perhaps not to turn off your cell phone. In rare occasions, we've lost somebody, and usually the cell phone is the way we reach out and get them back on. So with that, if there aren't any questions, we'll go ahead and proceed. Mr. Taylor?
Judge Edwards, one question.
Yes.
You've noted 20 minutes on the time with 5-minute rebuttal. Is the 5 minutes in addition to the 20 minutes?
No, it's not. It's when you see 5 minutes left, you really have 5 minutes left total. So
thank you, Judge.
All right. So whenever you're ready, Mr. Taylor.
Thank you. May it please the court. My name is Tim Taylor. I represent the appellant, Cynthia Taylor. And without getting into great detail, the facts of this appeal are as follows. Ms. Taylor was the owner of approximately 100 acres on US 1 located in St. Augustine, Florida. She entered into a contract with an entity owned by Stephen Bean for $5 million. Mr. Bean devalued her property and demanded a $1 million discount on the purchase price. Ms. Taylor refused and thereafter vowed not to sell to Bean. Bean then had his brokers, the appellees in this case, Segars and Coldwell, approached Taylor with a $4 million straw buyer contract. Segars Coldwell knew the appellant would never sell to Bean again and therefore was actively concealing and misrepresenting Bean's involvement in the straw buyer contract. Through the straw buyer contract, Segars and Coldwell were able to deceive Taylor into selling their property to Bean at a below market value. And once appellant Taylor discovered the scheme after closing, she brought suit against Segars and Coldwell for civil conspiracy, fraud, negligent misrepresentation, and breach of statutory duty under Florida statute 475.278. The trial court has subsequently granted summary judgment in favor of Segars and Coldwell, and for the following reasons, this court should reverse. The first issue is that the trial court erroneously determined Segars and Coldwell, who acted as transaction brokers for the $4 million sale, did not owe Mrs. Taylor statutory duty to deal honestly and fairly. The second point on appeal is that the trial court erroneously held the non-reliance clause bars all of Mrs. Taylor's claims against Segars and Coldwell for the following contested reasons. First, Segars and Coldwell cannot enforce the non-reliance clause because Segars and Coldwell chose not to sign the contract and opt into the enforcement of the provision. Additionally, the non-reliance clause by its express terms maintains Segars and Coldwell the duty of dealing honestly and fairly, and therefore cannot preclude claims sounding in fraud or misrepresentation.
Counsel, on that argument, is that your argument that the provision that's in the agreement that says in the performance of the terms and conditions of this agreement, each party will deal fairly and in good faith with the other? Is that the basis for that argument?
That's correct, Your Honor. And
Counsel, I guess on that particular argument, if we're reading the language of that provision, doesn't that provision seem to apply post formation of the agreement? I mean, it starts saying in the performance of the terms and conditions.
And Judge, that's a good point. And the facts of this case, I didn't get into great detail, but this was not only an affirmative misrepresentation at the beginning and the signing of the contract. There was a continued active concealment and further misrepresentation throughout the performance of the contract from the date it was executed until closing. And we went through great lengths to try to show the active concealment misrepresentations by these appellees. And therefore, although on its face, we would agree that it does not necessarily state in the beginning at time of execution, but certainly the performance of the contract has to be done fairly and in good faith.
But counsel, and that's a fair, and your brief makes that distinction very clear. And there may be some merit to that, but it matters, right? Because if you were to prevail based on solely on this argument, then it would change what is relevant at trial, right? All of the alleged fraud in the formation of the contract would become irrelevant, and you would have to focus only on the alleged fraud after formation. Do you agree with that?
If it was to this point alone, Your Honor, I would agree that we would now be talking about in the performance of the contract that they did not have the right to actively conceal and mislead the seller of the property.
At that point, it would be everything after the contract was formed, correct?
That's correct. And in this case, the trial court found that, this concealment and this affirmative misrepresentation was permissible not only at the beginning, but throughout the contract. And we wanted to raise that point that, even in this contract, there was a duty to deal fairly and in good faith moving forward, which was clearly violated with the facts taken in light most favorable to the plaintiff in this case.
Mr. Taylor, let me ask you this. Was there such a company or entity as Big Island Investments, LLC?
Yes, there was. There was, and it was a company owned by a gentleman named David Rohn. I happen to have spoken to him many times. But
okay, and that's the company was out in Texas, but it was Mr. Cate, is that right? Who was signing and initialing everything as though he were Big Island?
That's correct. Mr. Cate was a childhood friend of Mr. Beans and also a business associate. They grew up together in St. Simons Island, Georgia.
And let me just confirm this. There's no evidence that Big Island Investments LLC was ever the buyer, correct?
That's correct. They never were the buyer. They didn't pay any of the earnest money deposits. They didn't pay the closing funds. So they had no active participation in the purchase of this property.
And Mr. Segars knew that, didn't he?
He absolutely did know. And not only did he know that they weren't participating, he knew exactly who was participating. And he knew it was Mr. Cate and Mr. Bean, and specifically Mr. Bean, who Mrs. Taylor was never going to sell to because Mr. Segars was also the broker in the first failed transaction. That's how he did know. And he'd been kept abreast of the underlying litigation in this case. And he knew that Mrs. Taylor had active claims against the former entity known by Mr. Bean, and that this was a non-starter. So this sale was never going to occur, but for the participation of Segars and Coldwell to conceal the identity of Mr. Bean's involved. And so,
Mr. Taylor, so I understand the brokers have argued that paragraph 21 bars all of Ms. Taylor's claims. And one of your responses to that argument is a pleading argument that their affirmative defenses did not plead a third-party beneficiary theory. But isn't it true that they just, at least as a general matter, that the brokers pled that paragraph 21 bars Ms. Taylor's claims And if so, why isn't that enough from a pleading standpoint?
Well, because just because they state that paragraph 21 bars their claims, that they weren't necessarily claiming a third-party beneficiary status. They were just, I have to assume based upon the affirmative defense that by virtue of Mrs. Taylor signing the Big Island contract, that was the enforceability of our claims against her, not necessarily that the fact that these appellees were taking advantage of this contract as some form of third-party beneficiary, and that in fact it was intended to benefit them. I think there's a distinction to be made there, because when we go to Oceanic Villas, which all roads lead back to Oceanic Villas, when we deal with this clause, you have the underlying policy by the Florida Supreme Court stating that you can't have fraud by one of the parties and then have that party take advantage of that fraud. The fraud vitiates all terms of the contract. So if Mrs. Taylor is taken advantage of through fraud, then it doesn't matter that she signed this contract, and there'd be no applicability of that non-reliance clause unless she further agreed to waive her rights for any claims resulting from that fraud. And that's what we get into Oceanic Villas and Billington. So I think the pleading issue is a legitimate issue in this case because of the fraud and the nature of the claims. So, and then as we go through the analysis, I mean, we are at a somewhat a right moment in time if we were to ever get to the analysis of whether this claim in effect is even enforceable, because we do have Billington out of the fifth. We've got NM Residential out of the second that just came out interpreting not only Oceanic Villas and Billington. We also have the lower fees case out of the fourth. And all courts have always gone back to the analysis of Oceanic Villas and what that stands for, and whether this kind of clause, this non-reliance clause, can actually bar a claim for fraud. And so,
Counsel, if let's say theoretically, if you were to prevail, either on your argument that this was an unpled affirmative defense, or that they're not a third-party beneficiary because they were intended to sign the agreement. If you were to prevail in either one of those arguments, do we even need to get into Oceanic and Billington?
You don't, Your Honor. Absolutely not.
So on the third-party beneficiary, the signature issue, did you look for or did you find any authority anywhere directly on point dealing with this issue of an agreement that seems to expressly contemplate that a party would sign at least a portion of the agreement, then the party doesn't sign for whatever reason, but then addressing whether or not that party could be a third-party beneficiary?
The short answer is no. However,
no, you didn't look outside the jurisdiction, or no, you didn't find one?
No, we did not find one. We scoured the case law out there on this issue. I suspect it's because nobody would challenge it up on appeal if they didn't opt in, because when we get to the underlying issues of whether a party is a third-party beneficiary, there under the Supreme Court case of Mendez, there must be a clear and manifest intent of the contracting parties that the contract provision would primarily and directly benefit the party. And the problem here, when we have something like this in this contract, it holds it states broker joins in this agreement to evidence broker's consent to be bound by the provisions in paragraph 12 and 21. If the broker is refusing to sign this or fails to sign this, how can there be found to have been any intent to have been joined in as a third-party beneficiary? The intent is evidenced by whether they sign or not. And so I think sometimes we get into these issues where you have a provision that requires an opt-in and a party doesn't opt in. I know there's a litany of cases out there, for example, on class actions. If you don't opt in, you're not, or if you don't opt out, it's actually the exact opposite, I believe. If you don't opt out, you're part of the class. Here it's you have to opt in or you're not getting the benefit of the provision. They clearly had a right and an obligation to do so, and they chose not to. So I don't think they could ever, even if they repled, if the court were to reverse and reject their appeal and go back down to the trial court level and replat a third-party beneficiary status, I don't believe that they could ever prove that there was a clear and manifest intent that they'd be bound to that provision for failing to sign and opt in. And so I think the court.
Mr. Taylor, let me ask you this. Are they bound by the rest of the contract?
They're not part of the contract. And that's where we also get into, in order to, under the Morgan Stanley case we cited, it says unless the person is a party to a
well, but if they're here's my question or pondering here for you. If they're not part of it, then how are they bound by the obligation of to deal in good faith that you're talking about? I mean, they can't be both part of it and bound by part of it and not bound by the rest of it. It seems to me it's one way or the other.
Well, Your Honor, I agree. That's why we have statutory duties for brokers, and the statutory duties of brokers, there's duties to deal honestly and fairly. The brokers are a regulated profession under Chapter 475. The legislature has deemed that this profession needs to be regulated for the benefit and welfare of the public. So regardless of whether they're part of this contract or not, they have duties in these transactions to the parties. So we had to raise the issue that the parties would deal fairly and in good faith with one another, because the court found and was arguing that they were in fact part of this contract. But even if they're not, they still have statutory duties, Judge.
Okay, so to the extent there's a contract, that's just part of the overarching conspiracy that you allege?
Yes, they used a straw buyer contract in order to deceive Mrs. Taylor into selling her property to Bean. They then obviously took that straw buyer contract and made an assignment of that over to a Bean entity, which once again they filed paperwork with the Division of Corporations on Sunbiz, falsely identifying that this company was operating out of Dallas, Texas. Some registered agent nobody's ever heard about, and then of course after closing they get their hands on the property and then they update that information.
Mr. Taylor, I wanted to give you a brief chance to address the Appellee's argument about an essential element of your claims of damages, and specifically their contentions that the contract itself recites that the PUD had devalued the property by $1 million and that the $4 million price reflected a discount. And then, of course, some of the summary judgment testimony by Ms. Taylor herself about the value of the property. Can you share with us, your brief version of why you have raised a summary judgment issue on damages?
Yes. Well, first, the appellees are trying to invoke tipsy coachman, and there's absolutely been no finding on damages. So, as an initial argument, I don't believe that there's any basis on appeal to affirm based upon damages. But secondarily, just because there was clearly a devaluation of a property under the first transaction, and then there was the second transaction, a scheme to defraud to get the property for less than the market value at that time. And in fact, our expert property appraisal, Jason Lovett, has provided an affidavit and an appraisal report showing the $1 million devaluation from it's actually $1.2 million from the first contract that failed, followed by a $560,000 loss, which the property sold for under market value at $4 million, is actually worth $4.5 million. And this was actually somewhat confirmed by Segars' own expert that says the property value was actually $4.3 million. So there doesn't appear to be any dispute amongst the experts in the case that the second transaction that we're up on appeal about has a minimum of $330,000 lost by the defendant's own expert, as well as an $80,000 ill-gotten commission. So damages are undisputedly in excess of $400,000, and if you take plaintiff's damage calculation, up to $640,000. Your Honor, I see my time's expired. I'd like to save the remaining 3 minutes and 45 seconds for rebuttal, unless there's any further questions.
That's fine. Go ahead.
Thank you.
All right. And Mr. Sickler, when you're ready.
May it please the court. My name is Robbie Sickler. I represent Eddie Segars in this matter. This court should affirm the summary judgment entered below by Judge Maltz for the following reasons. One, the duties and obligations of Chapter 475 that were applicable in this transaction were not in fact breached. This is a commercial, not a residential transaction, and Judge Maltz rightly held that the disclosure requirements in 475-278 are inapplicable to this particular transaction and cannot be bootstrapped through 475-278.
Counsel, walk me through the statute. I've read the statute a few times, and I concede that I don't understand this argument. Maybe you can shed some light on it. It seems like when I read it, it seems like the duties, there's a list of duties for a broker, and then there's disclosure requirements. It seems like those are two separate things when I read it. How is the duty to deal honestly and fairly sort of tied to the disclosure requirement? How are they the same thing?
Your Honor, excellent question. If you look at 475-278 sub 5B2, the applicability of the statute, the sub 5 is the applicability, B is the disclosure limitations, and 2 states that the real estate licensee disclosure requirements of this section do not apply to non-residential transactions.
But Mr. Sickler, you're skipping over his question about it looks like two different things, which is the same thing I see. I see whether they're a transactional agent, a sole agent, or there's no agent, no broker relationship at all. They are required to deal honestly and fairly. You agree with that?
I do, Your Honor, and I was sort of moving back to that point with sub 2D. It specifically states one of the duties is disclosing all known facts that materially affect the value of the property. Judge Maltz found that the disclosure requirements that are not applicable to a commercial transaction are actually read out.
Counsel, I'm not sure those are the same disclosure requirements that were other than using the word disclosing and disclosure. I'm not sure that the statute can be read that way, but regardless, what about 2A, dealing honestly and fairly? That doesn't have any version of the word disclosure in it.
Correct, Your Honor. And what we would submit is that the duty to deal honestly and fairly here is to bring a viable real estate transaction at a fair price to the seller in order to allow her to sell that property at a price that is reasonable.
What does honestly mean?
A fair contract that's actually for value of the property, Your Honor.
Does it mean tell the truth or no?
I mean, in a bare definitional sense, yes, the word honestly does mean to tell the truth, Your Honor.
I mean, isn't that how we interpret statutes? I mean, how does the word honestly here in the statute not mean, at least in part, to tell the truth?
Well, I believe he did tell the truth. I believe that the contract for $4 million was a viable contract that met the requirements that she had and represented a fair deal for her.
First of all, we don't know. These are just this wasn't resolved. This has not gone to trial yet, right?
Correct, Your Honor.
Right. So these are all just sort of, this is a summary judgment below, right? So I guess the question is that we haven't been able to figure out yet. I mean, we don't know yet exactly what happened, but there's certainly allegations of dishonesty, are there not?
There are certainly allegations of dishonesty, yes, Your Honor.
And
Big Island was never intended to be the buyer, was it, Mr. Sickler?
I think that is somewhat disputed in this case. Big Island is a company out of Texas. The owner of that company provided his authorization for Vasicate to execute these documents.
Fair enough, Mr. Sickler. But if the other side has produced summary judgment evidence suggesting that Big Island was never the buyer, would you concede that is evidence of a failure to deal honestly in good faith, to represent that the buyer is Big Island when the buyer is in fact a wholly different entity connected to Mr. Bean?
I would not. In this particular instance, the simple fact of the matter is there is nothing but self-serving statements by Ms. Taylor that Mr. Segars was ever aware prior to the execution of this contract that Big Island was not intended to be.
What about the financial records about the earnest money and who paid that? I mean, isn't that, other than simply self-serving testimony, didn't she at least buttress it with some other record evidence?
Those, Your Honor, would actually be post-execution of the contract, which we believe would fall under a different standard.
Counsel, so her testimony is not competent evidence for purposes of summary judgment because it's self-serving. Can you Where's that rule? Isn't everybody's testimony oftentimes self-serving, or most oftentimes self-serving?
Oh, well, I don't necessarily disagree with you there.
I'm just not following that argument.
Your Honor, the simple fact of the matter is that this has been sort of a seller's remorse case in search of a claim, and her testimony has changed over time.
Look, that may well turn out to be the case. I don't know. But as far as summary judgment goes, and whether there's a dispute in the evidence, how is Taylor's testimony? How is that not competent evidence? You can't just say it's self-serving. That doesn't get you there. How was her testimony not competent evidence for purposes of summary judgment?
It may be competent evidence, Your Honors, but we've also moved more towards the federal standard, where we've moved away from a mere scintilla to some substantial material question of fact, which we don't believe her self-serving statements actually raise.
Mr. Stickler, one question that I had when reading your briefing, it appeared to me at certain portions in your brief that you were making a pleading argument that Ms. Taylor had failed to allege an affirmative misrepresentation theory, at least in her statutory cause of action, and had pled only a failure to disclose theory.
Correct.
Okay, so I'm wondering what you think about paragraph 204 of that count, which expressly pleads an affirmative misrepresentation. I mean, why isn't paragraph 204 sufficient to satisfy any pleading concerns?
Your Honor, I will tell you, I do not have the complaint sitting in front of me. I will take Your Honor at his word that paragraph 204 does in fact set out an affirmative representation. What I will say, though, in that regard is that no affirmative misrepresentation has been made. There is no, in our opinion, and I know we just had this discussion with Judge Eisnagel, there is no record evidence beyond the self-serving statements of Ms. Taylor regarding whether or not there was an affirmative misrepresentation prior to the execution of this contract.
Okay. So I think I understand your argument about the summary judgment evidence, but it sounds like you concede that as a pleading matter, if there's a paragraph in the complaint, especially in the count that sets out the statutory cause of action that alleges an affirmative misrepresentation, that's sufficient as a pleading matter.
Yes, Your Honor, I would concede that is sufficient as a pleading matter in that particular issue. One of the things that I did
we got off track a minute ago. We were trying to talk about the statute and the proper interpretation of the statute, and somehow we veered off into a discussion of self-serving evidence and whether there was sufficient summary judgment evidence. I'd like to go back to the statute and make sure I understand your interpretation of it. If we're looking at 2A, the requirement of dealing honestly and fairly, how does that only apply to resident? Your position is that only applies to residential transactions. I think that's your position.
That is not.
Okay, all right. So you concede that dealing the requirement that a broker deal honestly and fairly, you concede here today that does apply to commercial transactions.
Have never argued otherwise, okay. Your Honor. Okay. It is our interpretation, and we've been through this, and Your Honor may disagree, but it is our position that the disclosure requirements that are read out of it in paragraph 2D are being used to bootstrap into a 2A claim here. We have never taken the position that the enumerated duties in and of themselves are somehow read out of a commercial transaction. It is simply the disclosure requirements in 2D. This is primarily a failure to disclose the identity of the buyer case. That failure to disclose can't then be bootstrapped into 2A as a means of basically vitiating the fact that particular disclosure requirement has been read out of the statute in terms of a
I guess on that note, 2D doesn't really seem to apply to the allegations here anyway, does it? I mean, 2D says disclosing all known facts that materially affect the value of the property. And we're not talking about anything that affects the value of the property here, right? We're talking about who the identity of the buyer, right?
Your Honor, I would somewhat agree and disagree with you in this vein. We have argued this entire case. There has been no damage to sort of Judge Pratt's point because of the fact that the identity of the purchaser in this case does not create an economic damage. The summary judgment evidence, and I can provide citations to the record if you would like, actually demonstrate that Ms. Taylor herself has testified that she has suffered absolutely no economic harm as a result of Mr. Bean being involved with Rock Spring Farms.
Counsel, certainly that obviously is an issue in the back of probably everyone's mind as they review the case, but whether that is correct or not, doesn't it remain to be seen? I mean, the trial court hasn't reached that point. How appropriate is it for an appellate court to skip ahead on an issue that the trial court hasn't even reached yet? I mean, aren't we a little bit premature on that issue?
Well, I don't think you would be, Your Honor, because this was briefed and argued below. Simply because Judge Maltz didn't include this in his order or reach that issue doesn't mean that the court here on a tipsy coachman doctrine theory couldn't affirm based on the fact that there was a lack of damage because it was fully briefed and argued below. And one of the critical issues on the damage point that I would like to reach, Your Honor, is Mr. Taylor's contention that merely because one of the appraisers, or both appraisers, in fact, found that there was some elevated value of the property beyond the $4 million contract, I would argue that those both lack any sort of causation theory to demonstrate that any sort of loss by Ms. Taylor in this particular contract had anything to do with who the purchaser was. Neither of the appraisers set forth in their reports or in their deposition testimony that one of the reasons that the $4 million sum was obtained as opposed to whatever the purported appraisal value was related somehow to Mr. Bean being the purchaser as opposed to someone else. And in fact, I would point, Your Honors, on this particular issue to record evidence from Miss Taylor herself that says, on record is 8927, 8928, the deposition testimony of Ms. Taylor. Okay, but you chose voluntarily to sell the property for $4 million because you thought that's what it was worth, correct? Answer, I sold it for $4 million because I couldn't do any better at the time.
Well, we saw that in your briefing, Mr. Sickler, but it sounds like, I mean, you're acknowledging that, each side had experts that testified about the value, and putting aside the causation issue that you raised, just as a question of value, the experts agreed that it was worth more than $4 million at the time of sale, right?
I wouldn't disagree with that, but Your Honors, I think it's material to the question of whether or not she actually suffered any damages from a causation standpoint as to what the reasons for her sale were. And in record 9011, which is again additional testimony, she was asked, did you sign the $4 million contract agreeing to sell your property out of desperation? Yes. And in the contract itself, at line 419, Ms. Taylor wrote into the contract for sale, this is at record 6182, this property is being sold as is. Seller has reduced the price as compensation for the option of removing the public park at the sole discretion of the buyer.
Counsel, the value of the property aside, what about the commission?
Your Honor,
in a fraud claim, is that in play or not?
If I understand Your Honor's question, I believe that one of the issues here goes back to, as Mr. Taylor pointed out, Oceanic Villas. We just have a slightly different interpretation of what Oceanic Villas means. Oceanic Villas was a case involving a rescission, and the entire interpretation of the need for a waiver provision in a contract.
No, I'm talking about the damage issue still.
Oh, but I have to get through that to get to here, Your Honor, which is this is not a rescission case. In this particular case, while Ms. Taylor could have opted to rescind this agreement to try to state that it was fraudulently induced and unwind the sale, give back the $4 million and force my client to disgorge the $80,000.
I'm not so sure the $4 million would have to be given back in order to disgorge the $80,000. Do you have authority for that?
I don't have direct authority to say that the two are necessarily linked, but in terms of,
I mean, this court has held among, and I believe at least one other DCA has held that there's a private cause of action in 475. So what would the damages be for a private cause of action?
In this particular case, I don't think there would be any because she hasn't been harmed. The contract was affirmed. She has been bound by the terms of that contract because she ratified that contract. And under the terms of that contract, my client is entitled to the $80,000.
even if they committed fraud.
Well, we would argue they didn't, but
No,
yes.
no. That's not where we're at, counsel.
Yes, Your Honor. I would argue that because she ratified the contract instead of moving to rescind the contract, she is bound by the contract's terms. She cannot have it both ways. She cannot seek to
So you don't
affirm
think
the
the
contract.
sale, you don't think the sale and the commission are two separate things?
I think they're all part and parcel of the
They're all tied
contract, Your Honor.
together.
I do. If you
Sure.
ratify the contract, everything.
Well, let me
is
ask you
there.
this. Let's say this panel's not sure about that. Can we still tipsy coachman affirm based on damages?
I think you can. I think you can.
If we're
because
not, hold on, counsel, if we're not sure about the law on damages here?
Well, I think the law is clear on damages, Your Honor. And the simple fact of the matter
Counsel,
is,
give me the site. Give me the authority. I'm going to write it down. What's the clear?
I've already told you, Your Honor, I don't have a case citation for you on that.
Okay, well, give me, a rule, a statute, any
Well,
authority that makes it clear.
We have stated in our affirmative defenses, Your Honor, if Elizabeth, can you go grab that very quickly? That once you ratify the contract, you are actually bound by the terms of that contract. The contract calls for an $80,000 commission to be paid to the brokers. If you are bound by the contract through ratification, you cannot disclaim any of the various requirements under that contract. You cannot have it both ways. That is one of the.
Mr. Sickler, are the brokers, including Mr. Segars, are they bound by that contract?
Are they? They are not parties to the contract. They are intended.
Are they bound by the contract? Are they bound by the contract?
They are not parties to the contract, so they would not.
Okay, so how do they take advantage of anything? If they're not a party to the contract, how can they enforce their $80,000 commission?
Because they're intended third-party beneficiaries of those provisions.
Whether they act dishonestly and fraudulently, as it's alleged, and there is evidence, even though it's self-serving, and there is circumstantial evidence after the fact that Judge Pratt referenced. I mean, there is a jury question here, isn't there? If the case went to a jury, and if only Ms. Taylor testified, and then they showed the other evidence, the email congratulating Bean and his crew, and the payment of the earnest money and the payment of the deposits coming out of Bean's money. I mean, that may be events after the fact, but it's circumstantial evidence of the dishonesty and the fraud that your client knew of. I mean, that's a jury question. Whether you get to the damages or not, there's a jury question on that. And if she prevailed, wouldn't she be entitled to even $1 of damages, or you're saying zero?
I'm saying zero, Your Honor. We believe that the contract controls here because she opted not to rescind and to actually put the contract in place and sue on the contract. That's the entire reason that the non-reliance provision applies here as well. We would agree in a rescission case that Oceanic Villas would apply, and the non-reliance provision might not be enforceable. But under Billington, I'm sorry, yes, Your Honor.
I'll ask you the same question we asked your friend on the other side. Do you have a case that stands for the proposition that one can be an intended third-party beneficiary and have a blank in the contract that says if one wishes to avail himself of the protections of a certain paragraph, one should sign this blank, and then the party does not sign this blank, but is nonetheless considered a third-party beneficiary? Do you have a case citation that suggests that, holds that, deals with that situation at all?
I do not, Your Honor. All I can say to that is if one were to execute the contract in that manner, one would cease to be, by definition, an intended third-party beneficiary, and by logical operation would then be a party to the contract.
But counsel, that's the question is aren't they mutually exclusive? I mean, if the contract expressly contemplates that a party will be a signatory to the contract, how could they possibly also then, if they don't sign, how could they also then be a third-party beneficiary? Doesn't the contract's intent eliminate the possibility that they're a third-party beneficiary in that situation?
I would disagree, Your Honor, solely based on the plain language of the contract that says, except for brokerage agreements, buyer, seller, and broker agree that the terms of the agreement constitute the entire agreement between them, and they have not received or relied on any representations. You can't have an acknowledgement in paragraph in section 21 that represents the buyer, seller, and broker while simultaneously saying that it's not intended to benefit them in some way.
All right, thank you. Mr. Rosenberg, it's nice to see you. Mr. Taylor, You're up when you're ready. 3 minutes, 42 seconds. And you're muted still.
Thank you, Your Honors. Based upon the arguments made by Mr. Sickler, I'd just like to bring the court's attention back. When we talk about the applicability of Chapter 475 to commercial transactions, the appellees didn't really address the case of Century Land Development versus Whites. That was a Southern District of Florida case in 2009. In that case, they found that they obviously went through the analysis to show that under 475-278, the duties that the broker has are independent of one another. And in that case, that was an issue involving the duty to use skill, care, and diligence when providing appraisal services. However, the court in dicta did recognize that had there been a knowing misrepresentation concerning the property, that would have also resulted in liability. So, you know, the court is recognizing that in commercial transactions, you can't make these false knowing misrepresentations active.
So I think your opposing counsel conceded that the duty of honesty and fair dealing applies to all brokers, I believe. Could you address you wanted to address the damages issue for us again? I know you touched on it.
Well, yes.
Can we tipsy coachman on that? I assume you're going to say no, but tell us.
Correct, Your Honor. No, we can't tipsy coachman. And we did cite the case of Crosby versus Ashley, 291 Southern 2nd 12. That's out of the 3rd District Court of Appeal. And that held that where there was a material concealment by the broker, it did bar recovery of a commission. And that also involved the sale of actually dog kennels here in Miami-Dade County, where the broker concealed the fact that, in fact, the property had been rezoned, and yet the broker wanted his commission for the sale of that property. The court found, that a broker.
Counsel, what's the case name again on that? I'm sorry.
Crosby versus Ashley, 291 Southern 2nd 12. And so, at a bit, when we start talking about the types of and characterization of these damages, we have a brokerage commission that would never have occurred, but for the honesty and loyalty duties being complied with and informing Mrs. Taylor that Mr. Bean was going to be the purchaser and ultimate holder of this property. The transaction would have been dead on arrival. So,
Mr. Taylor, and just one last question for me, because I want to narrow down, the issues that are in play and understand where the disagreement is between you and Mr. Sickler. Do you agree with Mr. Sickler that a concealment claim masquerading as a misrepresentation claim would not be actionable in this context because it's a commercial transaction? I understand you'd probably disagree about whether that describes the claim that you've brought and the claim that you've proved up at summary judgment. But if we're dealing with a concealment claim masquerading as a misrepresentation claim, would you agree that that's not actionable under the statute?
Yeah, and I just need to understand the question a little bit better, Your Honor. I would agree that if a broker just did not voluntarily provide certain information that he didn't know whether or not the other party needed or wanted to know, that later that this disclosure claim couldn't masquerade as a duty of honesty and loyalty. However, when you have the broker having intimate knowledge of certain facts that the seller would obviously control whether they're going to sell this property, and that broker takes steps to hide the fact that the buyer is somebody they would never sell to. This is not a non-disclosure case. These are affirmative steps. This is active concealment. These are misrepresentations made to the seller. So I just, when you pose the question, I just got to be careful how I answer it. I do agree that garden variety failure to disclose certain facts that may be known to the broker, but not necessarily needed to be known or wanted to be known by the seller at that time of the contract. Yeah, I agree with that. I agree. But clearly, as pled and as the evidence show, I mean, look, we have absolutely no communication with Segars and Coldwell, with Big Island and David Rome. Zero. It is all with these defendants, which Mrs. Taylor has vowed never to sell to. They knew what they were doing were wrong, and they.
Counsel, I think your time has expired.
Thank you, Your Honors. I appreciate your time today, and for the foregoing reasons, we respectfully request that you reverse the trial court's ruling in this matter.
Judge Edwards, I think you're muted as well.
Right over there. Well, very interesting case. It was well briefed and well argued, and we will be in recess. Thank you.
Thank you, Your Honors.